We start to also watch these rain chances decrease as we go into the middle of the work week. But by the weekend, we're getting back into those upper end 80s, taking a decent cool down going into those days as well. But rain chances are expected to return for Sunday, Monday, and next Tuesday. We'll keep some isolated showers and storms in the forecast for those days there. And that's going to push us back right around 90 even for a couple of areas. Looking at our lows, we have a few days where we dip into the 60s, but not too far into them. We only go about to 68 or so. It's going to make for some foggy starts and some cooler conditions for each morning.
Alrighty, well, don't forget, WAAY 31 gives you 24/7 coverage you can count on. Local news, breaking news, and severe weather. You can watch WAAY 31 on all of our streaming platforms and download the only weather app with 3 live Doppler radars. Don't go anywhere. WAAY 31 Law Call is next. Y'all have a great night.
LawCall is provided in the public interest by Timberlake League and Brooks, which pays an advertising fee to this station.
This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's an Ask Us Anything night, so call in your questions on any legal topic. Maybe you've got a question about pool safety. Maybe you've got questions about auto accidents. The 31 Law Call number, 256-536-0077. Call in and be live with us on the air and ask your question live. You can also text your question to that same number. You can also email your question on any legal topic any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we will pull some out. We've got some of your email questions ready tonight. We've also got Heath Brooks from Timberlake League and Brooks ready tonight to answer questions.
So good to be here. Watched the soccer game today. Saw Spain beat
Very exciting.
Argentina. I was an Argentina fan. I'm a big Messi fan, but you know.
So exciting, so many good games, and to watch everybody that's been visiting the United States and to see the reactions from people around the country welcoming people from different cultures and different places. Really nice.
I'm pretty sure everybody who came from outside of the U.S. had a really good time.
Yeah.
And I've seen nothing but positive.
Yeah. So call in your questions with us tonight, 536-0077. While we get some of your questions in, we've got tonight's You Make the Law Call video. Okay, so train crossings always make me nervous. But when you get to something like this, I guess it's a car carrier and they parked, I don't know if they went dead or why they wound up stopped across the railroad tracks. Vehicles are never going to be able to compete with a train. The speed, and have you had many train accident kind of cases?
I have done a few train accident cases, and these types of cases, in this scenario, the car gets stuck on the train track. It's not going to be on the train. Yeah. It's not going to, there are certain times though when, we're looking at another one of these bars malfunction. And when the bars malfunction and cause problems, cause wrecks, get people trapped, there's a situation there that potentially it is the organization that's upkeeping the bars. Okay. Different states have different laws regarding railroad crossings, but the big thing about railroad cases is that there's a lot of this law that actually comes from the federal government. Back in the late 1800s, early 1900s, when the railroads were being built, these big railroad companies had a lot of influence. Yeah, they had a lot of power. They had a lot of influence with the government, and this was the big lobbying effort. What could we provide to the railroads to ensure that the railroads were protected? So a lot of laws came out in the late 1800s, early 1900s that protect railroads, and they haven't changed since then. And so you have these federal laws that preempt over the top or prevail over the top of state laws that sometimes insulate folks when they get injured at a railroad crossing, if it's something other than the bars. Sometimes with the bars aren't being watched. They should be. There's not an insulation for that. If the track itself is not upkept, there could be some liability there. And each state may handle that differently, and then the federal government is over the top of that, handling some of those laws themselves. So it can be a very complicated area of the law that we've moved through on occasion.
So do the train companies take responsibility for the tracks, or is that that's the government?
You can't. Yeah, the train companies actually do take responsibility for the tracks. In fact, you can't touch them. I mean, that's the railroad companies that are responsible for maintaining those tracks. And typically the railroad companies, I know when I was working with the land trust in North Alabama, we were trying to get a crossing of a train track so that we could enter a piece of a preserve that we had protected. And the problem with what happened is that the train company said, hey, look, we'll help you out any way we can, but we're not going to let you cross our train tracks.
Okay.
And there's nothing you can do because it's all governed by federal law.
Okay. So call in your questions. We got this email question tonight. This is from Mary. Mary says, it's been over 6 months since my daughter turned in her claim for water damage in her condo. The insurance company said the claim was fine and they would pay, but she's received nothing. It's been 6 months. Is that normal? Is there some legal time limit for this kind of thing?
So anytime, there's multiple different potential statutes that you have there. When I say statutes and limitations, what I mean is time limitation. So if someone is negligent, that means that they do something wrong. The fancy term is to the reasonable satisfaction of the jury, they've done something wrong. And basically what that would entail is a 2-year time limit in that scenario. If it's a breach of contract, that's a 6-year time limit in the state of Alabama. So in this scenario where there's water damage, you probably have a negligent act that's going to carry a 2-year time limit. And then you may have a claim against your own insurance company that has a 6-year time limit because you have a contract with your insurance company. So what needs to happen in those scenarios is don't let an insurance company put you off. Don't let them just say, oh, you're fine, we'll get to it when we get to it. A couple of reasons for that. One is a time limitation situation, but the other thing about that is evidence is like water. Yeah. It evaporates. And so having somebody who can come into one of those areas, gather the necessary evidence, gather the documentation can be critically important when the insurance company puts you off for 1.5 years, 2 years, you're right up at the eve of a statute of limitations, got to file a lawsuit and you got nothing.
Yeah. And by the time you try that case, if you have to try it, it may have been 3 years since that.
And all the evidence is gone there.
Yeah. Okay.
And you have a much more difficult time proving a case. And as a plaintiff in a case, you got to prove it.
Yeah, it's your responsibility, your lawyers.
That's right.
Let's talk a little bit about class actions. So there's been a couple of different data breach cases going on out there.
That's right.
Whether it's medical records and somehow your data has been breached, or it's something financial, or it's school records.
That's right.
What are you seeing with those kind of cases? I mean, is this something, if I get a notice in the mail, do I need to join this class action?
You know, take it seriously because, you know, in our society now, what we're really seeing more and more and more of is stealing identities. And they're done in large groups. You know, a whole company has all of their employees' data stolen, or all of their customers' data stolen, and sometimes this information is pretty significant. So we're talking social security numbers, we're talking date of birth, documents, checks, you know, somebody pays with a check, photographs of the checks, which can be replicated, you know, and then taken to the bank in cash. So there's a lot of information that can be stolen, you know, when there is a data breach. And the question is what happens? Well, you know, there's some damages. If God forbid somebody opens up a credit card in your name, there could be damages against the company that allowed the data breach to occur. If you know, sometimes there's some monitoring that the company will be required to do to monitor someone's credit report. You know, the damage to damage to your credit may be there. If you have somebody running up a bunch of debt, it's not you. You know, you could have a problem. So there are a lot of damages that can be associated with that. Sometimes it's punitive damages.
Okay.
And punitive damages, if the conduct is bad enough, like in other words, if you didn't properly, you knew the steps that you had taken were not going to be sufficient to protect your customer's information.
Yeah.
You could be on the hook for punitive damages, and what that means is that is a situation where a jury or a judge says we're going to award these damages to the plaintiff to keep this defendant from ever doing it again.
To punish you.
It's a punishment.
A punishment.
Civil punishment.
We got in this text question. I co-signed with my granddaughter when she was 18 at the time to get a car. Was supposed to be me as the co-signer. It actually turned out her as the co-signer and me as the buyer. Okay, so it's switched off on that. We voluntarily surrendered the car. Now we've got a settlement letter. They're wanting $2,800. I tried paying it, but they won't accept credit cards, and I tried taking out a loan, but I can't get one. They say I've got until the end of September. What can I do about that? Can they sue me or garnish my wages?
Okay, first off, there's a lot to unpack there.
Yes.
It doesn't necessarily matter whether or not you're the co-signer or the buyer. If you co-sign on the note and the buyer defaults, then you are the buyer. You have the same amount of responsibility as the actual buyer as the co-signer. And so if you have to surrender the vehicle, what happens in that scenario? And it's always going to be determined by what your contract says with whoever you purchased the car from. But generally what's going to happen in that scenario is the car company's going to take your car. They're going to sell it at an auction for whatever the fair market or whatever they can get for it. And the balance that is left on your note, sometimes those finance charges, that interest that you should have been paying, now is going to be your responsibility. It's going to be the co-signer and it's going to be the buyer's responsibility. And what happens when you have that $2,800 is the company that you owe the money to has some options. One, they can attempt to collect on that amount, and they can do that by filing a lawsuit against you for breach of contract. And they'll file that lawsuit. Generally, it's going to be in a district court, which means the jurisdiction is under $20,000. They can get a verdict against you, and they can try to garnish your wages until such time as that amount is paid back. The other thing they can do is just let it go. And that generally doesn't happen, but there are some tools you do have at your disposal. Read your contract carefully. Oftentimes, the person who repossesses the vehicle or takes the car back has a responsibility to ensure that that vehicle is sold at the fair market value. So if it was sold below what the fair market value was, you may have an argument that they actually breached the contract and could get out of a sticky scenario.
Good. Okay, if they come back and they have gotten a judgment, or they are trying to get a judgment for $2,800,
Right.
Can you talk to them and come up with a deal instead?
Typically speaking, there's going to be a bunch of different times you can talk to any kind of lien holder or lawyer that's seeking money, and a lot of times the judge is going to encourage it. You get there for trial, they say you owe $2,800, the judge is going to say, hey, look, have y'all sat down and talked about this, see if you could work something out, payment plans or something like that. And then after your wages are garnished, that is a process. You actually have to file as the person who's trying to get the money back, or the company who's trying to get the money back, actually has to go to the court and file an action for garnishment and go through a significant process, and they can't garnish more than an X percentage, can't garnish your disability payments. There's some rules there that you have, hoops that you have to go through. But short answer to your question is yes, you can always talk it out.
Make a deal.
Yep.
But get it in writing. If you make that deal, get it in writing that
That's
they're
right.
releasing you for $1,000 or whatever it
Absolutely.
is.
Always get it in writing.
In writing. We got this email question in from Darren. Darren says, does the insurer send the car repair check to the insured person or directly to the body shop that's given the quote? If it's to me, the insured person, could I legally choose not to do the repair? It's a rear end crash with $1,300 worth of damage. Could he keep the money? Does the insurer care if I do that? Is there any downside to doing that other than, the back of the car is not going to look good? Can you just take the money?
Usually you can.
Okay.
Usually in today's world, generally what an insurance company is going to do is they're going to send somebody out to assess the damages themselves. There are times where it's good to be on what I call the nose of the dog rather than the tail of the dog, and I will advise people that I represent to go ahead and take their car to a body shop if the damage is significant, get an estimate while we're trying to figure out whose insurance is going to cover what, so that we have that in the bag and we can move forward quickly once we find out the answer to those questions of who actually has insurance, what the insurance is, who the adjuster is, those kinds of questions we need to ask before we can get a claim resolved.
Yeah.
And so, but most of the time, if it's a minor damage, you got an older vehicle, there's a rear end collision, the insurance company's going to come out, they're going to look at the bumper, they're going to say it's $1,300, what do you want me to do with it? And that assumes that you don't have a lien on the car.
Oh, yes.
If you owe somebody money,
Right.
say you're paying, the dealership every
Right.
month or the credit company every month, then the insurance company has to send that check to the person you owe the money to.
Gotcha. Good.
Yeah.
We're going to take a break. We'll be right back answering more of your questions tonight. It's Ask Us Anything night. Stay with us.
Call, the Tennessee Valley's only live legal call-in show for 30 years and counting. Presented by the award-winning personal injury and wrongful death law firm Timberlake, League & Brooks, featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Meservey, attorney Bobby Marsh, and hosted by family law attorney Sharon Doviet. Your rights, your calls, live. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. It's an Ask Us Anything night, so call in your questions. The 31 Law Call number, 256-536-0077. We got in this text question, so somebody, you know what, hold it before we do that. What were you doing this weekend? You brought us some pictures.
Yeah, I went out, this was not during the week.
Okay.
I went out and had to walk around a land trust property up on Green Mountain, and took a couple of pictures of some friends up there.
What is that?
This is the caterpillar that eventually turns into a buck moth. And the interesting thing about this caterpillar is that do not rub up against it.
Ooh.
It is poisonous.
Really?
It will sting you. Yes, those little barbs will stick in you. It is not pleasant. There are a couple of 3 different species of caterpillars in the state of Alabama that are actually poisonous. And if caterpillars have these kinds of spikes on them, chances are you don't want to touch them.
Okay, I've heard of a pack saddle kind of bug before. Yep. This same kind of thing. What is this?
This is one of 2 species of scorpion that live in the state of Alabama. One of them is on the coast. This is the southern unstriped scorpion.
How big is that in person?
It looks a lot bigger in that photo. It's probably about the size of my thumb or smaller. And they'll sting you, but it's not poisonous. Okay. It's more like an ant sting.
Are you looking for this stuff when you go out there, or you just happen across it?
You keep an eye to the ground. You know, not necessarily looking, but not looking. Not looking.
Not looking.
Yeah, this is actually on Green Mountain. You know, and we deal a lot with what's called the recreational use statute. Yeah. And so, you know, when you go out and you hike, there's a lot of, I'll get calls from people and they'll say, hey, look, I was out hiking and, you know, there was a hole in the trail and I hurt my ankle, or, you know, I fell off the bridge, or I fell into the creek and the trail didn't go. I got lost. Yes. You know, and what do you do about that? And, you know, Alabama, most states, I work in Tennessee and Georgia as well as Alabama, most states have what they call a recreational use statute. And what that means is that if you go out on someone's property, whether it's public or private, really, and it is for recreation. In other words, this is a piece of property that's open to the public, it's open for the purposes of recreation, then if you get hurt, it's kind of like you have assumed the risk of going out onto this property. So if you get injured, you really don't have a claim.
Okay. You're out in the wild.
Yeah, you're out in the wild. You're on a trail. You got to take care of your own self. But there are some exceptions to that we've looked at over the years. One exception would be if this organization is having a business. In other words, if there's a yard sale there, or if they're selling something like they have an event and they're selling things there, that could be an issue. But for the most part, the recreational use statute. So if I got stung by that caterpillar and had to go to the hospital, guess what? I'm out of luck.
What if they charge you admission to get into it? Because, you know, a lot of the state parks charge a little something, or they have the little booth up there.
It doesn't apply in a state park scenario. Okay. No, it doesn't. Okay.
I was just watching out for snakes and anything else we come across.
Well, yeah, you know, you don't think about the scorpion or the moth or the caterpillar that could hurt you, but yeah.
We've got Stacy on the line with a question from Huntsville. Hi, Stacy. Thanks for calling. What's your question tonight?
Hey, so I was on a trip in Atlanta a couple weeks ago, and I got rear-ended pretty bad, and it did a lot of damage to my car. But I was just wondering if I need to get a Georgia attorney, or if I can get an attorney from here at home.
Good question, because it sure would be easier, since she lives here, to have somebody here.
And I do a lot of work over in Georgia, so I can speak to this. Georgia law is different than Alabama, and for someone to practice or to actually represent you, you do need a Georgia attorney, or an attorney that's licensed in the state of Georgia to protect you there. There's markedly different laws in Georgia than there are in Alabama. So, you know, I would recommend contacting the Georgia attorney and, to handle that for you.
Okay. Talk to us a little bit about, there have been some lawsuits going on about medical companies steering people towards certain law firms, right, for representation.
Yeah.
Now, that's okay to do, right, to recommend a law firm that they know. If you're in the medical profession and you see somebody that's hurt, can you tell somebody,
Sure.
hey, I know a good lawyer?
Sure, you can. I mean, you can give a list of lawyers that they may go to. Sometimes, you can give an opinion that, hey, look, you may need a lawyer to handle this. I mean, we deal with it all the time. I think the turn is that if this medical facility is set up to take advantage of people who have been injured, whether that's through a car wreck, whether that's through a fall, and they're not interested in providing medical treatment, and they're more interested in perpetuating a fraud on folks that are victims. And what I mean by that is that they'll provide medical care that they charge exorbitant amounts for, and you don't get the care that they say they've provided. They have an attorney there that's sitting in the lobby signing forms and things like that, or they're providing legal advice. There's you got to be careful, when after something, because you be in a vulnerable state when you've been in a wreck and you got all these people that are trying to call you that shouldn't be. You shouldn't be receiving any calls from anybody trying to get you to be their client after a wreck without you asking. That's illegal. But you're dealing with these calls, and then you're also trying to get better. When you go to see a lawyer, when you go to see a medical doctor, make sure you feel comfortable. Make sure that you trust that the practitioner that's providing you medical care is doing it on the up and up, because what's going to end up happening is it's not going to end up good for you. You're not going to get better, and it's not going to end up good after that case is resolved, even if it does. I mean, these lawsuits are now working through the state courts in Alabama for some of these companies that have been doing pretty bad for folks.
Interesting.
I hate to see it.
We've got this text question. The writer says, I had chemo leak into my arm from the IV, causing damage, but I can't sue because no lawyer will take my case. Why not? Now, that's not a whole lot of information there. Do you have any? When you're dealing with medical, this would be a medical malpractice case,
That's right. So
getting a lawyer can sometimes be hard.
Basic medical malpractice is that you have to, the person who performed the procedure had to have done so in a manner in which no other practitioner of that type would have done so in the country. They call that the standard of care. And if there is a breach of the applicable standard of care, there could be medical malpractice. The thing that stops you in a medical malpractice situation is it a known complication? So what you end up doing when you go into a medical facility is you say, hey, look, you can treat me. I'll give you the right to treat me. I understand there are risks associated with what you're going to do, whether that's a surgery, whether that's providing any dental work. You're going to sign what's called an informed consent. Part of the problem whenever you get an injection, they call that an infiltration burn. Part of the problem is that can happen as a known complication. The question comes whether or not the doctor, nurse, practitioner should have recognized it as an infiltration burn in time to stop it. Was it a failure to diagnose? Gotcha. And you have to look at the medical records to determine that. So get your medical records if you want to have your case reviewed by an attorney. Okay.
We're going to take a break. Be right back. Answer more of your questions. Hang on.
League & Brooks, which pays an advertising fee to this station.
If you haven't gotten your questions answered tonight, here's how to get in touch with Heath Brooks with Timberlake League & Brooks. They are personal injury attorneys, so everything from car crashes to medical malpractice. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon is a family law attorney. She does divorces, child custody, and the like. She can be reached at 256-539-7337 or www.sharonfamilylaw.com.
One of our callers was calling about a car accident in Georgia. So how long does she have to do something about it?
Yeah, it's important. Georgia is 2 years. There's some other laws in Georgia. If there are, and that's one thing I should have asked. There are if you have multiple plaintiffs in Georgia, and that means multiple people that are injured in the same wreck. There's some letters that need to be written to the insurance company.
So don't put it off.
Make sure you're on that.
See you next week.